Following the interviews to select a short list for the next National Director of Public Prosecutions, the process has come under fire. The Democratic Alliance has threatened legal action to interdict aspects of the interviews and objects to the inclusion of Advocate Menzi Simelane. At the same time, civil society is calling for more transparency and public participation in how the NDPP is selected. We're joined by legal practitioner Barnabas Xulu to unpack what this means for justice, accountability and public trust. Barnabas, appreciate your time. Now, let's talk about where you come in. What is your end goal? To stop Cronje's appointment specifically, or to force a more transparent process for all the candidates?
Thank you very much, and thank you to the viewers at home. The basis of our objection is actually contained in the objection that was submitted, that contains 99 pages of content, basically laying out the conduct of Advocate Cronje, as well as that of Advocate Bauer, SC, who have been basically caught exchanging confidential information, which was not supposed to be in the hands of those that were representing the accused person. So we are not saying she is guilty, but what we're saying is this panel needs to consider her reaction to these allegations, because the information is supported with evidence, and the effect of that conduct has led to the delay in the implementation of serious programs, environmental programs that are looking at the marine and the coastal communities of the Western Cape. And I must say, I'm a citizen of the Western Cape. I know how the communities, the coastal communities, have been sidelined in the major fisheries-related activities in this province. The funds that the firm has successfully recovered from the US were earmarked and are still earmarked for that, because these funds have not been able to be used because of the interference by Advocate Cronje. Now, there has been a delay of at least 6 months, that an amount of more than 120 million rands have not been used for this purpose. And it is purely because of the interference the two advocates were involved in. And we're saying, if now we are going to have the similar person getting to become the head of this institution without having resolved this issue, then it means the future is bleak to those young people that should at least be supported and be trained to get involved into various maritime projects as designed and acknowledged, not only by the South African courts, but also by the US federal courts. Because this settlement is not a settlement that was only done in South Africa or in the UK, but it was also endorsed by Justice Kaplan in the Southern District of New York. Now, to have someone who was not involved in the matter interfering by leaking that confidential information, which ends up being manipulated by Advocate Nazreen Bauer, because she did not have sufficient information and she did not understand the matter. And I saw also in the interview the way she tried to attack the firm. You could see that the case is being mischaracterized. First and foremost, she claims to be her case. On what basis does this case become a case? She was never involved in the resentencing procedures that were taking place in New York. She was never involved in the litigation that was taking place in Jersey. It's a way of imposition, but which the South African public at least needs to be aware that, is this person fit and proper if she was able to interfere in this fashion? That is our objection, and we are saying she should have been asked and received a public scrutiny, because, I mean, there may be violation of Section 41, subsection 6 of the NPA Act. These matters were dealing with environmental crimes that have been confirmed by the US courts, and in any event have been confirmed by the South African courts as well, that what Mr. Bengis was involved in were environmental harms.
So, Barnabas, the absence of questioning to Grenier about this case and all the objections that you raise does not necessarily mean that the panel did not consider your objections, right? Because members of the public are not privy necessarily to what considerations the panel makes when putting forward the names that they do recommend to the president. How do you know for sure that the panel did not consider your objections?
It is her submissions during the interviews that she made it clear that she has never been favored with the objection that was prepared by us. She was hearing it for the first time, but nonetheless, even though she has not seen the objection, but she was able to make comments, and very unfortunate comments which were untruthful, starting with the mischaracterization of the case itself. She had no regard of what exactly were the complaint and what is contained in the 99 pages. In the 99 pages, it is the evidential emails that she was exchanging with Advocate Power. It is the memorandum which was prepared by Advocate Menzi for the NDPP, Advocate Patoyi, to say there is nothing wrong that has been committed in the settlement of this matter by BXI or members of the NPA that we work with, which is Advocate Molele and Advocate Mohadla. That memo should have called for a clause in challenging any form of settlement, because it's detailed how this rare kind of a settlement or achievement has been made. Everything was above board. There was an approval by the Minister of Justice for us to be involved in this settlement negotiation, by the former head of NPA, Mr. Advocate Sean Abraham. Everyone was on board, the Minister of Agriculture, Forest and Fisheries, which in turn tells you that even the cabinet was aware of this settlement. But all of a sudden, someone who had nothing to do whatsoever with the matter, as she was only heading the ID, she, in fact, gone to an extent of reporting the matter to the police, until the police made it clear to her that you are not going to be part of vindication or fighting internal NPA wars. And they chuck her away.
Barnabas,
I could not believe when she said there is a prosecution that is pending. This is so unfortunate. The people that are suffering here are the coastal communities because of their conduct.
Barnabas, why do you choose to proceed via a public objection rather than a complaint route first? And how do you respond to people who say that this is politically motivated?
There is no politics. There is no personal, any motivation of that nature. Here, we see the impoverished coastal communities being denied the benefit and the support that they should be getting from these funds. And she was instrumental in distorting the information around that case. And we're saying, before you give her this challenging position, at least let's have, like all other candidates, let's have her scrutinized publicly. Let's have her answering these questions publicly to see whether is there any justification of the conduct that she got involved, because it is inconsistent with the Constitution. And when we believe that the panel set up its own rules, and amongst its rules was that there would be public objections, those public objections would be given to the candidates. The candidate will start by making answers in writing, and then they will also be asked publicly. All other candidates, which is evident, they were questioned. I'm not going to mention their names, but there were questions. They were questioned on the objections. It is only her who basically received a darling what you call interview, whereby she was shielded, but at the same time she had an opportunity of attacking those who are fighting for the improvement on enforcement in the marine sector, for those who are fighting for the balancing and proper oceans economy to benefit all the coastal communities, which include the youth and the adults.
Barnabas, tell us about your abalone case with the state, including Benji's. You were ordered to pay some 20 million rand back to the state. And tell us about Cronje's then involvement in any kind of litigation that you may have with the state.
Okay, put it this way. The issue of the 20 million rand fees is unrelated to this matter. And I'll opt not to talk about it because it's unrelated. This is a South African court order that we were talking about, which recognizes the global financial settlement, which came up at the value of 7.5 million US dollars, as well as the 1.250 million US dollars that was recovered by the firm. But the 7.5, after making payments to the other parties that were assisting in the recovery process before we enter into a global financial settlement, had to be paid some fees. And what remained is the amount of 7.1 million US dollars that is currently being held in Kara. So the 20 million has got nothing to do with this matter. The appointment here was done by the Department of Fisheries, and it was done by the Minister of Justice as well as the head of the NPA, then Sean Abraham, which is decision, they remain binding until such time you take them to court. But it is not only just the settlement. The settlement received recognition from the federal courts. Now, the South African government is finding itself being in contempt, basically, of that ruling, which is a stipulation and order granted on the 2nd of October 2018 by Justice Kaplan. No compliance whatsoever. And this whole distortion is happening on the back of a former head of ID, being Advocate Cronje, interfering by sourcing the information. When they see that the information is actually proving that everything was above board, then the same information was manipulated into the court papers that have been filed. But she's not part of this.
So Barnabas, that's what I was trying to get at and inferring actually, is that Cronje is in no way involved in any litigation that you have against the state.
Yes, but if you look at that 99 pages, you see her name. You'll see her name sending emails. You know what is contained in that email from Advocate Bauer? Advocate Bauer says, in fact, there's a very specific paragraph, and when you read the objection, you'll see it. It says, the clarification sought by Mzinyati from Molele should be along the following lines. After receiving his memo. So Advocate Molele has sent a memo to Advocate Mzinyati detailing all the dealings in the matter. Now he says, you may want to tamper with the language so it seems more internal. Advocate Bauer knew very well that she was not entitled to this information, and it had nothing to do with the 20 million issues, which, it has its own day whenever we deal with it. But wanted Advocate Molele to think that this information is internal. And, to your shock and to the public shock, is that I ended up answering all the questions that were raised by Advocate Bauer, who was at the time representing a suspect criminal. And if you look at the memo, you'll see who is that suspect criminal that was being investigated, and she wanted information in order to protect that suspected criminal. You read the objection, you'll see that. And maybe that is where you'll understand the issue of the 20 million, where it comes from. All the matters that were done by BXI, we happen to have been successful in them, and the government of South Africa has claimed victory to that. This information is reported to the annual reports of the NPA as achievement of the NPA. But what is happening is that there is a denial of implementing the maritime programs that are supposed to be benefiting the coastal communities who, at this stage, the crimes in the oceans or in the marine of this country remain entrenched because there is no effort. These programs were properly supported by international organizations, which to date, they still ask the question, what transpired to the funds that were repatriated to South Africa? Those funds are still sitting in the criminal asset recovery account. For whose benefit?
All right, very many questions remain there. Barnabas Xulu, thank you very much for your time this afternoon. That is Barnabas Xulu, and he is a director of the B. Xulu and Partners law firm.